Good evening, and thanks for joining us on our weekly AJA Zoom event. Welcome to any people who are joining us for the first time this week. We also have people watching on Facebook and people listening to the audio recast on Thursdays at midday and Sundays at 4 p.m. on J-Air Community Radio at FM 88 in Melbourne or at j-air.com.au. Welcome to everyone. My name is Robert Gregory, and on the screen you can see Dr. David Adler, who's president of the AJA, as well as our guest tonight, Mark Friedgut. Now, the format tonight will be a presentation, followed by the chance to ask questions. So if you'd like to ask a question, the best way is to raise your hand with the reaction button. Written questions can also be placed on the chat function, and if we have a chance, we may get to some tonight as well. So this week, as everyone would have seen, we witnessed concerning scenes out of Israel, as mobs of protesters attempted to prevent the recently elected Israeli government from carrying out its mandate to implement its election promises. As David mentioned, we were both in Canberra this week for meetings with MPs, and we were asked to comment on the situation, talking about it. So later on, we're going to share an excellent response which we received from someone in Canberra. So what got the protesters so worked up about? And what is the appropriate response from Australia's Jewish organisations? Mark Friedgut has a rich history of communal involvement. He's currently Vice Chairman of Kehillat Kadimah in Sydney, and he's also a barrister at the Sydney Bar, so he's well placed to comment on the legal aspects of the reforms. Mark, thanks for joining us tonight.
Well, it's a great pleasure. Thank you for having me. And may I say, firstly, kol hakavod to AJA for all the outstanding work that you do. It is really needed, and it is most appreciated. Robert, are you happy for me to dive in?
Yeah, take it away.
Well, the situation is that although the proposed judicial reforms have been put on hold, it is, I think, vitally important to understand what the proposed reforms are and what they are not. We live in an age of fake news, but what shocked me to the very core of my being over the past couple of months was the total falsehood, the flagrant misrepresentations made often by people in the highest authority in relation to the proposed judicial reform. According to media reports, the most inflammatory assertions were made by some of the most senior Israeli leaders over the past 3 months, including statements by the former Attorney General Avichai Mandelblit that the legislation is a regime coup, that the court has a duty to stop, that there was the mayor of Tel Aviv who said that this is turning Israel into a dictatorship, which can only be solved by bloodshed. And then, of course, in a breathtaking display of chutzpah, President Biden has also apparently weighed into the issue. And according to a report in World Israel News of yesterday, President Biden expressed strong concern that Israel gets this straight, referring to Netanyahu's planned judicial overhaul. They cannot continue down this road, he said, and I've sort of made that clear. And according to the White House spokesman yesterday, she said that they know our strong views about the importance of democracy to the US-Israeli partnership. They know where we stand on this issue. So, notwithstanding the fact that the reforms have been put on hold, it is, I think, imperative that we educate ourselves as to the facts, as to the truth. And my intention tonight is to seek to explain as briefly as I can, it's a bit complex, to explain as briefly as I can the current state of Israeli constitutional law and why some consider that the judicial reform is absolutely necessary. But I hope to illustrate that if every single one of the reforms as originally proposed, whether by Rothman or by Levine, were to be enacted without any amendment whatsoever, Israel will relevantly be similar to Australia, to New Zealand, to the UK, to Canada, and therefore, it follows that the surprising statements being made to the effect that the proposed reform gives rise to a regime coup and are anti-democratic are entirely false. Now, whether one agrees with the reforms or not, one thing is beyond doubt. They cannot possibly be described as anti-democratic. But what I fear is anti-democratic is to try to set aside a democratic election by way of threats and protests, particularly when one is doing so on the basis of false and, dare I say, seditious statements. And regretfully, the more that the days pass, the more convinced I am that this has got nothing whatsoever to do with judicial reforms, but really is a case of people trying to undo the last Israeli election. And I think it was illustrated perhaps yesterday when merely hours after Prime Minister Netanyahu announced a 1-month pause of the judicial reform legislation and the start of negotiations, protest organizers said that they will continue with the demonstrations. Now, I note that yesterday, the ZFA and the ECAJ published another joint statement in which they wrote, amongst other things, that they have been in awe of the hundreds of thousands of Israelis from across the political divide and from many sectors who have come together to protest week after week. Now, let me make it clear. I pray for peace. I pray for unity in Israel. It scares the hell out of me, the incredible disunity at the moment. But let me say categorically that there are two aspects of the recent protests about which I was not and am not in awe. The first is the demonstrably false narrative about coups and dictatorships. And the second is the crossing of red lines by threats of reservists and army personnel not to serve, putting the very existence of the state in jeopardy. And my real fear is that the ballot would have appeared to have been lost to the power of the street. And I think that that is a very serious issue in relation to democracy as a whole. So with those words, let me quickly jump into the issue, and I'm going to have to go through it fairly quickly, I fear. Israel was established, as you know, in 1948 as a parliamentary democracy. Parliamentary democracies are based upon the separation of power, the theory that liberty is most effectively safeguarded by the separation of governmental powers into those branches, namely the legislature, which is of the people, by the people, for the people, that makes the law, that is the Knesset, the executive, which is represented by the cabinet that executes the law, and the judiciary, represented by the courts, which applies the law to justiciable controversies, that is, disputes between persons about rights and liabilities as they exist or are deemed to exist at the moment that proceedings are instituted. Israel, like Britain, does not have a written constitution. And let me just say that there are some people who believe that this whole concept of judicial reform is something which is new and has just come up recently. That is not the case at all. People in Israel, scholars throughout the world have been talking about Israel's need for judicial reform since about the mid-1990s. In 2003, the extremely well-known American jurist, Robert Bork, former Solicitor General, a former professor of Yale Law School in America, a former nominee for the American Supreme Court, wrote a book called Coercing Virtue. And in that book, he deals with judicial activism, and he compares America, Canada, and Israel comes out by far the worst. And he says in the second chapter of the book, the second chapter of chapter 4, which he devotes to Israel, he says, imagine if you can a Supreme Court that has gained the power, to choose its own members, wrested control of the Attorney General from the executive, set aside legislation and executive action when there were disagreements about policy, altered the meaning of enacted laws, forbidden government action at certain times, ordered government action at other times, and claimed and exercised authority to override national defense measures. Imagine as well a Supreme Court that has created a body of constitutional law despite the absence of an actual constitution. He goes on to say, no act of imagination is required. Israel's Supreme Court has done it all. Now, how did that happen? In the first 40 years of Israel's existence, Israel's Supreme Court was fairly activist, yet it maintained a number of basic rules that led to restraint, and it enabled it to reach its highly balanced approach. It was a highly, highly respected, highly regarded Supreme Court, internationally respected and internationally regarded Supreme Court. Then what happened is that in the late 1980s and early 1990s, the judges started getting more and more activist in the Supreme Court under Justice Meir Shamgar, who was the president of the court from 1985 to 1995. And then most particularly, indeed, the fons et origo of the issues which Israel is confronted with today is Justice Barak, who was a justice of the Supreme Court of Israel from 1978 to 1995 and was president of the Supreme Court in Israel from 1995 to 2006. What happened was that in 1992, Israel passed two basic laws. Now, the basic laws were laws which were meant to be fairly significant, but they didn't have any greater constitutional standing than any other law. The two laws that they passed in 1992 were the basic law, freedom of occupation, which forbids restrictions on the right to practice any vocation, and basic law, human dignity and liberty, which prohibits infringements on a person's dignity, life, body, or property. Now, each basic law contained a clause which said that there shall be no violation of rights under this basic law, except by a law befitting the values of the state of Israel, enacted for a proper purpose, and to an extent no greater than required. And it also said that Israel is a Jewish and democratic state. Now, the provisions of these laws, unlike some other laws that Israel had, did not claim to be entrenched. They didn't claim that you needed any specific majority in order to change these laws. They were not considered to be on a higher normative level than any other Knesset law. They could be changed by ordinary legislation. They didn't purport to be constitutional. And in fact, interestingly enough, both of these laws were enacted by the Knesset in the middle of the night without even a majority of the 120 members of the Knesset being present. The law dealing with liberty and dignity, which is the most important one for our purposes, passed by a vote of 32 to 21, tiny majority. Those were the only members of the Knesset that were present. The law dealing with freedom of occupation, 23 to 0. But then what happened was that in 1995, in a case called United Mizrahi Bank, the president of the court, President Barak, referred to those laws as being, his words, a constitutional revolution, enabling the Supreme Court to strike down, to annul, to void any legislation of the Knesset which is inconsistent with those basic laws. Now, in that case, interestingly enough, it was what lawyers refer to as obiter dicta, because in that case, the laws clearly were perfectly valid and they were not problematic laws in any way. They were not struck down, but that's what he said in a remark. Now, the statement that he made that those laws were constitutional came as a big shock to members of the Knesset. For example, in a 2009 symposium, Minister Michael Eitan, who was a member of the Knesset at the time, said that none of the Knesset members exercised any constitutional power, believed that they did. No one said that they were establishing any type of constitutional court. In fact, that was specifically raised, and the question was asked, will the court have review of these laws? And the answer given by the chairman, who had promoted the laws, was that no, the power will remain with this House. The Constitution wasn't mentioned by any member of the Knesset, and the proof that nobody considered that this was a major law having constitutional effect is the fact that on the day after the law was passed by this tiny the tiny majority, with very few members of the Knesset even being present, there was nothing about it in the newspapers at all. There was nothing about it the next week in the newspapers, nothing, zero. That law was passed, and based on that law, the Supreme Court ultimately has held that it expanded their power beyond the power that any Supreme Court in any parliamentary democracy in any place in the world actually has. And the reason for that is that terms like human dignity and liberty are vague and amorphous terms. They can be applied to anything. So what the Supreme Court has done is that they've said, because there's a law giving people human dignity and liberty, we can actually make laws or impose laws on you, the Knesset, relating to economic rights like welfare, giving powers. They said that they have the power to order the government, for example, I jest not, to increase welfare allowances. There's no court in the entire world that believes that they've got the power to dictate to the legislature that it must raise welfare allowances to people. They did that under the guise of human dignity and liberty. But the problem is that it is for the Knesset to decide how much they spend money in terms of competing budgetary requirements. That's why the people elect the government, the Knesset. It is government by the people, for the people, of the people. It gets worse because President Barak, in a series of cases which began shortly after his appointment, said that they could void a law on the grounds of unreasonableness. That unreasonableness, if they believed that the Knesset passed a law which was unreasonable, then that in and of itself was a basis to declare that the law was void. So it endowed, according to the Supreme Court, the court with almost unlimited power, more, as I say, than any court in the Western world. Every governmental law or administrative decision becomes, in fact, appealable, and every appointment can be challenged in court on the grounds of some misconduct in the candidate. So let me give you some examples, and each of these examples are genuine examples. In 2017, the date may be wrong. I intended to look it up. Forgive me, I didn't, but I think it was 2017. The court ruled that Prime Minister Netanyahu, who for security reasons, on the basis of advice from his security apparatus, was going to close the PLO offices in Jerusalem. The court enjoined him from so doing on the basis that the court said there was going to be an election a few months away, and it was not appropriate for him to do something as extreme as close the offices of the PLO a few months before an election. Yet this year, when just the week before the election, then Prime Minister Lapid decided to give up certain territorial water concessions to Lebanon, and that was 1 week before the election. So parties went to the Supreme Court for an injunction because, there was the precedent. The Supreme Court said, no, it's perfectly legal. It's perfectly reasonable for him to do it. So it becomes arbitrary, discretionary, and capricious. What the judges want to do, they can do. They are the super legislature. Let me give some other examples. And this one is the one that makes me, frankly, feel the most sick of all. In 2021 and 2022, the committee that decides on the nominees for the country's highest prize, namely the Israel Prize, in its wisdom decided to award the Israel Prize to a professor from the Hebrew University who was a vocal spokesperson for the BDS movement. Now, that prize, the Israel Prize, is under the purview of the Minister of Education. And the Minister of Education said, you've got to be kidding. Over my dead body. We are not giving the highest prize to a vocal BDS supporter. So they went to court. And the court sided with the committee. They said, no, it's unreasonable. Now, I just ask the question, how can Israel, or we expect other countries to enact anti-BDS legislation when its own Supreme Court rules that it is unreasonable for the Minister of Education, who has responsibility for the Israel Prize, it's unreasonable for him to say that a vocal BDS supporter cannot get Israel's highest award. Another example, the court ruled that it was unreasonable to compromise and close Bar-Ilan Street in Jerusalem for several hours on a Shabbat, even though a public committee of prominent religious and secular Jews, highly representative of Israeli society, held that it was reasonable to do so. No, but the court in its wisdom, they know what's reasonable and what isn't. They know better. They are the council of sages. They are the bee's knees. The examples can be multiplied and multiplied. The court this year ruled that Derry could not serve as a minister in the government. Now, whether one agrees with the decision or not politically, the point is that there was no actual law enabling the court to do so. They did so simply on the basis of the fact that they said it is wholly unreasonable that a person who's been convicted of a criminal offense is a minister in the government. So they made up new law. That was this year. This year, a week or two ago, the minister responsible for the police, who wanted to give instructions to the police in relation to the protests, was told by the court, no, you can't do that. You can only give policy, but you, as the minister responsible for the police, you can't give them instructions. You can't do that. Now, the mind boggles. They've struck down the Haredi exemption law in relation to deferments for study at yeshiva, which was negotiated politically, very difficult negotiations, whether one agrees with it or not. What is it the role of the court to determine that that was not reasonable? In 2013, in 2014, in 2015, the court struck down 3 times laws about illegal immigrants in order which the government, by large and significant majority, had sought to impose. They struck those laws down on the grounds that they were unreasonable. So Israel, the Knesset, cannot control its immigration policy. It is bizarre. They've ruled that the government can't open private prisons, can't have a contract with private contractors for prisons. Now, in 2018, the Knesset passed a law allowing the Minister of Interior to revoke citizenship or permanent residency for convicted terrorists, and to prevent their social benefits. But the Attorney General, and we'll come to that, how the Attorney General does it, because the Attorney General in Israel is a bureaucrat who is not part of the government, but controls the government. The Attorney General said that that was unreasonable, and she said what they had to do was they had to give them alternatively temporary residence status, thus giving convicted terrorists full benefits such as unemployment insurance, child support, disability insurance, and social security payments when they get out of prison. So not only do they get the pay for slay if they kill people, but they also get Israeli benefits. It is bizarre. And who knows what they'll do next, because they are a law unto themselves. If tomorrow they decide that it's contrary to international law for Israel to have Jerusalem as its capital, they may make such a ruling. And what do we do then? I'm going to be, I see the time, so I'm going to be skipping a lot of things that I wanted to say, but I'll just say two more things before getting on to the reforms. One, the selection process for Israeli Supreme Court justices is bizarre in that it is probably the only country in the world, certainly the only democratic parliamentary democracy, where the judges have a veto as to who is going to come onto the court with them. And as a matter of practical reality, there have been some great jurists who disagreed with them philosophically, jurisprudentially, for example, that they were overstepping the mark in terms of their judicial activism. And those jurists who were nominated for the Supreme Court obviously did not get on. In my opinion, everything I've said so far pales into insignificance when one hears this next thing I'm going to say. And that is the role of the Attorney General. What has happened was that in a case in 1993, the High Court determined that the Attorney General, known as the government legal advisor, is in fact like the long arm, as it were, of the court, and that the advice that the Attorney General gives to the government is binding on the government, so that if the government wants to pass a law and the Attorney General says to the government, no, you can't do that, it's unreasonable, the government is bound by the decision of the Attorney General. Nowhere, I venture to say, in the entire world, I don't even have to say parliamentary democracies, I'm sure that that is unique to Israel. It is extraordinary. The Attorney General is the legal advisor to the government, but doesn't give advice, rather gives commands. The Attorney General can intervene in any government action and tell the government that they can't do it. And the absurdity is that the decisions of the Attorney General are final even when it's not based on legal questions, but on conclusions about policy. So we have this situation that currently in Israel, the government can only appear in court by the Attorney General, so that if the government is sued, but the Attorney General decides that he or she, now it's a she, does not want to defend the government because she agrees with the person suing the government. The government is the only party in Israel because they've done away with standing. Anybody can go to the High Court, anybody at all. They've done away with standing. They've done away with justiciability. The only party that can't go to court is the government if the Attorney General decides that he or she is not going to defend the government. That is the absurd situation, and the absurdity is illustrated by what has happened over the last 3 months. That the Attorney General, now I want you to think about this for a second. The Attorney General and the Supreme Court have ruled that Prime Minister Netanyahu cannot get involved in any significant way in promoting the current judicial reform, although he's the Prime Minister. Why? Because he's got criminal charges against him, and therefore he's got a conflict of interest. Now, the absurdity of that is that no matter what happens, if every single one of the reforms go through, it cannot possibly affect Netanyahu's trial. But the people who do have a clear conflict of interest are the Attorney General, because if the reforms go through, it cuts down this bizarre power of the Attorney General, and it cuts down the bizarre power of the court. And yet it's the court and the Attorney General, presumably with a straight face. I don't know, I wasn't there, I couldn't see their face, but presumably with a straight face, the Attorney General and the court said, you, Mr. Netanyahu, as Prime Minister, cannot get involved in this judicial reform because you've got a conflict of interest. We haven't, but you have. Now, of course, the court has been vigorously criticized. If people think that it is simply this new right-wing government that is criticizing, it's absolutely wrong. A former president of the court, great jurist by the name of President Moshe Landau, who retired in 1982, has said that this court displays arrogance and pretension. They see themselves more or less as the governing elders of Israel. They are there to look after Israel. It is, as Professor Bork said, judicial imperialism. And the sad irony, he said, is that the Supreme Court in Israel, operating with the basic law that specifies Israel's values are both Jewish and democratic, is gradually producing an Israel that is neither Jewish nor democratic. So that's the reason, in short, and I had to skip out a whole lot, why one needs the reforms. Very quickly then, because I see I'm over my time already. Very quickly, what are the reforms? They can be summarized just in 7 points. Firstly, that the Judicial Appointments Committee will be changed, so no longer will judges have the final say as to, and no longer will the judges have a veto. Now, judges will still be on the committee, whether you adopt Levine's plan, which is that there'll be a committee of 11, or Rothman's plan, where there'll be a committee of 9. The judges will still be on it, but they will not have a veto. But in most countries like Australia, like New Zealand, up until recently, in every country like England, it's changed in England, but in Canada still, and America for the federal courts, judges are actually appointed by the executive. That really means by the Prime Minister or the President in cabinet, behind closed doors. So for people to say that this reform is some way anti-democratic is not only bizarre, it is dishonest. So that's the first, and what has been so far the only reform that has gone to the Knesset. Who's going to be on the committee to appoint judges? Reform number 2 is that they bar the courts from overturning basic laws. Now, that makes perfect sense. The court says that the basic law is a constitution. Well, if the basic law is a constitution, then nobody is above the constitution, not even the judges. That's the fundamental principle of constitutional law. So they cannot have it both ways. They cannot say it's the constitution, but they can change it. The reason that this is part of the judicial reform is because the only way they can get this judicial reform through without having it overturned by the court is by saying it is part of the basic law, which the court says is constitutional. The third reform is that to strike down any law. So they're still allowing the court to review the legislation, which is something that you cannot do in Australia unless it's contrary to one of the provisions of our constitution, and we don't have a Bill of Rights, so it very rarely happens. If somebody takes something without just terms or something like that, or there's a conflict between state and federal law, but doesn't happen often at all. In England, it never happens. They can never overturn laws of the parliament. But here in Israel, they say you can overturn it, but you must sit as a full court, and there's got to be a majority of, according to the one plan, it's 11. The details don't matter because these things always change in committee and in the various readings. The point is to have a super majority of the court is not radical. In America, there's always a full bench. In Australia, when you have a constitutional matter, almost inevitably, the High Court will sit as a full bench, every single judge sitting. So to say that's undemocratic, again, is dishonest. The fourth reform is that unreasonableness is no longer a ground to overturn legislation, which seems pretty self-evident because unreasonableness is not a ground anywhere in the entire world. So again, not radical in my opinion. And the fifth, which I think is frankly the most important, is to cut down the role of the Attorney General, to make the Attorney General a legal advisor and not somebody who can give commands to the government which they are bound to obey. That's the fifth. And then the sixth reform, which is probably the most controversial, but frankly, it shouldn't be. But Netanyahu felt it was controversial. So he said, I will not be pressing for this one. I will give this up. He said that last week, is the override provision that if the Supreme Court says that a law is invalid, there was going to be a provision whereby in certain circumstances, the Knesset could override that decision. But as I say, Netanyahu is not pressing that, but may I say, in virtually all countries in the world, Australia included, if the court did interpret a law in a certain respect and the government wants to overturn that, to see that, in effect, that decision, the court passes new legislation. So that's not controversial. So those basically are the reforms. None of them are radical. None of them are anti-democratic. So I'm sorry that I've exceeded my time, but that, in my view, is the nub of the reforms.
Well, thank you, Mark. That was, you stated that really eloquently, and I think everyone can see the court and the legal system has definitely overstepped its bounds quite a lot. We might just go to David for a update about what's happening, and then we'll go to some questions.
Okay, well, thank you very much. And as we do each week, and I can see there are quite a few new people on this week, at the end of the event, please go to the AJA website, jewishassociation.org.au. We need your support in order to continue our work. You can apply for it to be a member if you're not already a member, make a donation, do something. Now, as far as next week and indeed the week after is concerned, those days coincide with Yom Tov for Pesach, and of course we don't hold events during the Yom Tov. So I'll just foreshadow that we have a non-PC event, as sometimes we do, coming up after Pesach, we have Emeritus Professor of History, Bill Rubenstein, who will be joining us, and we'll be having a look at the voice, the proposal from an Australian historical perspective. So, okay, we're ready for some questions.
Yeah, so we've got a lot of interest. We can see a lot of written questions, a lot of questions on here. I mean, we've got 150 people watching on Zoom and more on Facebook, on the radio. So there's a lot of interest here. Let's start with Helen. Do you want to ask your question?
Can I just make a plea to keep the questions as brief as possible? Helen, please unmute.
Okay. Yes, that's a very comprehensive and convincing review you've given us of the problems which are facing the Israeli people today. But the question seems to me to also hinge upon the faults of the government that's bringing out the Israelis in their thousands, hundreds of thousands, to protest what seems a very reasonable argument that you are giving. So could you please comment on how the unsuitability of the Israeli electoral scheme is contributing to this unrest? So many parties with a low level of nomination get them qualified, and you have the instability of governments falling every 12 months.
Well, thank you, Helen. May I say that I think, if you look at the last 4 or 5 elections, this is the first election where Israel actually has a very clear majority. And so it's really the first time in many years that Israel has actually been able to do things, because in the previous 4 elections, there wasn't a clear majority. This time there is a clear majority. And it seems to me that really what the problem is that there are people who are very unhappy about the fact that this government has a clear majority, and that really what the protests are about are not about judicial reform. Because, I mean, I put it to you, you be the judge. I'm saying this to everyone. You be the judge. You've heard what the reforms are. They are not radical. These are things which apply in the UK, in Australia, in New Zealand. They are not radical at all. And yet, why are so many people protesting to the extent they are? I think that there are 2 things. Number one, I would guess, and I know that this sounds patronizing, but I believe it fully because I've spoken now to so many people, including educated people, including lawyers. Most people don't have a clue what the judicial reforms are about. And they are being told by their leaders, they are being told by, the mayor of Tel Aviv that this is a case of dismantling of democracy, that this is a case of a dictatorship coming to being. They are told by Mandelblit, the former attorney general, that this is regime coup. They are told by Yuval Diskin, the former Shin Bet head, that this isn't that this is not a right-wing government, it is a fully terrorist government. So if leaders of that kind are saying those type of things to the people, you can understand that the people will believe it. But I want to say this as well, that let us assume that there have been 100,000, because it's very difficult to know exactly how many people there are each week protesting. But let's say it's 100. Let's say it's 200,000 people. There are over 9 million people in Israel. So you can have what could be a very vocal minority who can really seek to impose their will. And that, I think, is an extremely dangerous scenario, particularly when people feel it's appropriate, soldiers, to say it's appropriate to say, we are not coming, we are not reporting for duty. And frankly, that is untenable.
Yeah, I agree. That's definitely outrageous. There's a legal elite trying to usurp power, and the government was just elected, so it definitely has a mandate to act. And mobs in the street shouldn't be able to dictate. But let's go to Andy. I think you're next. Would you like to ask your question?
Okay, thank you. I live here in Israel. I see the extremes that's going on. I think a lot has to do with the frustration of the COVID, the frustration of prices going up. I don't like arguing with people. Could you please give me 3 points that I could mention to people quietly? Do you know? Because when I ask people, what are the reforms? I don't know, but it's not the democracy. We have to fight it. So if you could help me with just 3 simple things one-on-one, I'd appreciate it. Thank you.
Yeah. So what I say to people is the following. I say, in the first place, what they're trying to do is they're trying to bring Israel to be in line with countries like Australia, like New Zealand, like Canada, where in those countries it is the prime minister that appoints the judge. Here it's been unusual, and the only country in the world where the judges have a veto. So what they're doing is they want to have a committee to appoint judges, which will include judges, but they will not have the veto. And surely that doesn't affect democracy, because if it does, it means that America's not democratic. It means that England's not democratic. It means that New Zealand and Australia are not democratic. It means Canada's not democratic. That's point number one. Secondly, I say to them, they're trying to change the law so that the court can't overturn legislation or decisions of the government because they think it's unreasonable. And you can give the example of immigration, where the immigration from Africa, where by large majority, and this was majorities which included the left wing, they had imposed certain laws and the court overturned it. Now, you ask them, well, do you believe that the Knesset is to represent we, the people? It's to represent us. If so, then surely we cannot have this elite who determines what is and what is not reasonable. Surely the judges are not more qualified than we are to determine what is or what is not reasonable. And our views are the views which we speak through the Knesset. Then I say to them, do you know who the most important and the most powerful person is in Israel? And people say the prime minister, people say the president, some people will say, okay, the judges. And you say, no, you know who the most important person in Israel is? It's the attorney general. Do you know that under the current regime, the attorney general can nix any law that the cabinet makes, that the Knesset makes, can say that law is unreasonable. I'm not going to defend that law in court, and you can't defend that law in court because I'm not going to defend it, and you can't get your own lawyer. Now, surely that is unreasonable. And you cannot say it's undemocratic to change the law in that respect, because they don't mean every single other country in the world that is a democracy, like America, like the UK, like Australia, New Zealand, Canada, is not democratic, because none of those countries have an attorney general that has those rights. Then, the most controversial aspect is the override provision. And I give examples to people. I say to them, and interesting enough, Netanyahu has said that he doesn't want to press it because people feel it's too controversial. It was the most controversial of all the laws. But think about it. Let me give an actual case. In about 1969, in a case called Shalit, the Supreme Court in Israel determined that it was who is a Jew, and that somebody who self-identifies as a Jew, for example, because they love Israel, or they want to fight for Israel, and therefore they say, look, I'm Jewish. I may be a practicing Catholic, I may be a practicing Muslim, but I'm also Jewish, that's good enough. They can be a Jew. It was by 5-4. So 4 of the judges said, are you guys off your how can somebody it doesn't make any sense. What the Knesset did in 1970, and this was, Labour was in power then, it wasn't Likud. In 1970, they passed a law overturning that and said, no, a Jew is a person who's converted or is born to a Jewish mother. Nobody batted an eyelid and said, oh, well, you overrid, you changed the decision of the High Court and therefore you're acting undemocratically. Not. That happens in Australia. It happens in every country. So I don't think that it's fair for people to say that it's undemocratic. And the truth of the matter is that the reason I got passionate about this is because I was asked by a very good friend of mine in Israel to start speaking about it, because he said that Israelis even don't understand. And the reason that Israelis don't understand is because the media is so obsessed against this law. So they are frankly conveying false information and a false narrative.
Thanks, Mark. Well, we have to keep the questions very brief because we had a lot of questions waiting. Victor, would you like to ask a quick question?
Victor, can you unmute and ask a question? Perhaps Victor's having some difficulty doing that. Let's move on to the...
Dino Razel, would you like to ask your question?
Yep.
Two questions. Who appoints the Attorney General? Is that the courts? And secondly, is the Supreme Court and the High Court in Israel, are they similar to the way the Australian Supreme Court and High Court work? Victorian Supreme Court and the Australian High Court.
Yeah. Okay, so the two questions, the first is who appoints it. There's a committee that appoints the Attorney General, and the Attorney General is a bureaucrat who comes through, applies. There's a whole methodology of applying. So the last Attorney General was appointed during the time of the previous government. I think that they're part of the committee, but they don't have any veto rights over the committee. So you have an Attorney General who can have a very different view to the government. As to Supreme Court, High Court, there's only the Supreme Court in Israel, and it acts in different capacities. So it acts as the Supreme Court, it acts as the High Court in constitutional matters, but it's the one court of 15 judges. And might I say that in the Australian High Court and in the American High Court, and in America, how many hundreds of millions of people there are there and how big Australia is. Both of our high courts and the American Supreme Court have on average about 70 or 80 cases a year. Israel's Supreme Court have over 1,000 cases a year because they don't have standing. Anybody can bring any case to the Supreme Court, except, of course, as I say, the government, the Attorney General, doesn't want to allow them to do so.
Crazy. I think, Greg, I think you were next. Would you like to ask a question?
Yes, can you hear me?
Yes, we can.
I have a question. Thanks for this very interesting discussion. Could the circumstances that we are presently seeing been avoided had Bibi Netanyahu, in the process of campaigning, delivered the message of some of the change and shifts he needed to make? Or was he fearful that he would not get into power? Or was the delivery, could that have been different? What could have been different to avoid this absolute crazy situation today?
Not having been in Israel at the time of the electioneering, I can't comment in that. But the one thing that I can say is that judicial reform was very much on the agenda of those people who came into power. They campaigned on it. It was part of their election platform. And there've been many people who've engaged in elections with judicial reform high up on their platform. Bennett's number two, Shaked, was a strong proponent of judicial reform. Professor Daniel Friedman, who was from Ehud Olmert's party, he was a former Attorney General, he was strongly in favor of judicial reform. So judicial reform isn't something new. As I say, what happened was that when the reform started being mooted after the elections, the Supreme Court said to Netanyahu that he couldn't get involved, which was really an extraordinary thing. They placed a gag order on him. And in fact, now I think he's been given 5 days to show cause why he hasn't breached that, because he made a speech last Thursday night from England where he spoke and explained the judicial reform.
Hey, Victor, is your
Yes,
sound
I'm okay. Thank you very much. I'd like to ask a very simple question. Why Israel hasn't got a Senate?
Well, I suppose that, one would have to go back and work out, what they decided to do in 1948 when they were formed. I mean, not every country has senates, and they're different constitutional models. I've never really, and I'm not saying it's not the case, I've never really heard it said that there's been some controversy in Israel that they should have 2 separate houses. I would imagine there's a cost involved in having 2 separate houses, and given that Israel's a really small country of now, about 9+ million people, probably isn't necessary. But I would imagine, Victor, that what your question is really going to is that those people who are the opponents of judicial reform try and answer the propositions that I'm giving by saying, oh, yeah, but you can't compare Israel to Australia or to New Zealand or to Canada or to America because they've only got 1 House of Parliament. Therefore, you've got the checks and balances. And of course, we all know that that's just nonsense. I mean, when has it happened? Seriously, when has it ever happened that a parliament by majority have wanted to pass a law, but the Senate has been the brake and has said, no, you can't do it. I'm not saying it doesn't happen. I'm not saying it can't happen, but it's not something, frankly, since I've been in Australia and I arrived here at 6:37 a.m. on the 16th of June, 1989, I don't remember it ever happening. May have, I don't know.
Reuven's ready to go, I think.
Yeah, my question is, to my understanding, all over the world except Israel, governments are elected as lawmakers, statute lawmakers, and the judiciary, the function of the judiciary is the practical application and definitions put to those statutes. In other words, if a question of law comes up, ask someone expert in the area of law, not the judge. He'll hear the case, pass judgment, etc. But in Israel, it seems to be back to front, the other way around. I don't know any other place where it works like that. Can you comment on that?
Yeah, no, you're absolutely correct. I said that's the whole concept of the separation of power, that the legislature makes the laws, the executive executes the laws, and the judiciary applies the laws to a dispute, a justiciable dispute before them. And they've done away with justiciability, they've done away with standing, and they've considered themselves as like this super legislature. It's precisely right. That's one of the biggest reasons that one needs the judicial reform, in my opinion.
100%. David, was there something you were going to share with us?
Yes, I'll just bring it up. Give me about 10 seconds. Hopefully, I'll be able to.
You can see there's a lot of questions in the chat, dozens of questions, but
what we're going to show is a quote from a meeting that we had just yesterday afternoon with Simon Birmingham, who's the Shadow Minister for Foreign Affairs, and this is his words exactly. And I think there's a lesson here for some of our Jewish organisations as well. He says, well, it is important to recognise, and I say again, that this, referring to the judicial reforms, is a domestic political debate within Israel. Because there's been a lot of people who have been arguing that external pressure and interference is something that's a good idea, in addition to all the tsuras that Israel has to deal with. Let's pile on a bit more. So we were actually very impressed with Simon Birmingham's political maturity and understanding and general support for Israel, but saying this is an internal Israeli debate. Yeah. So I think it's time and wrap up.
Yeah, well, just want to thank you so much, Mark, for joining us. It's been a fascinating discussion, and you've shown us what's really going on, what the real threats to democracy are. And as I mentioned, we've had a lot of written questions. Unfortunately, we weren't able to reach them all, so it's definitely generating a lot of interest, a lot of people listening. Let's all hope the Israeli government can find the appropriate path through this. If anyone wants to read your piece that you wrote in the Jewish News, it's available on our AJA Facebook page. And don't forget, everyone can keep up to date with what AJA is talking about through our Facebook, through all our social media, Instagram, Twitter, YouTube, LinkedIn, everywhere. And also our email list, free email list. Subscribe at jewishassociation.org.au. Find out about upcoming events. But for now, we're going to wish you all a good evening. We look forward to seeing you. The date will be the 19th of April is the next AJ Zoom, as we mentioned, because of Pesach. So wishing everyone a Chag Sameach, and we'll see you all then. Thank you again, Mark.
Thank you.